Yes, please.
May I please, Lordship, I'd like to mention the listing of these matters in orders column, Lordship.
For what, which matter?
Lordship, on the date fixed, the petitioners could not appear before the superintendent of police, Lordship. Therefore, extension of time frame.
Why he could not appear?
Lordship, due to communication gap.
Communication gap. No mobile phone. Not working. Mobile down. Tower. Next week, hobo or next week.
May I please, Lord? My Lord, I beg to mention item number 29, my Lord.
What do you want? Tell us quickly.
My Lord, in this case, my Lord, the petitioner has expired, my Lord, has become infectious.
Is it infectious?
My Lord, yes, my Lord.
Infectious. You ask some colleagues there sitting there, then you mention again. You make a mention whether it is
My Lord, it
infectious
may be
or not.
abated, my Lord.
Huh?
Abated, my Lord.
Abated.
My Lord.
You again ask, consult your friends. You consult your friends and make a mention, no problem.
My Lord, then I may be allowed to matter pass out for the day, my Lord.
No, we'll pass a order today just now. You just consult, no problem.
Pending matter, one Porimur Rajbangsi, my lord, title is Rajbangsi. He has been, your lordship was pleased to issue notice returnable on, my lord, 29/4/21.
So Rajbangsi from Bangladesh.
It is shown as, my lord, wrongly. Other fathers, parents, all that.
There may be Rajbangsi in Bangladesh also. Who says there is no
No,
Rajbangsi?
my lord, 100%, my lord, all papers are there, my lord. As he could not be able to appear, my lord, coming from Lakhipur, my lord. He is a, my lord, cook of Lakhipur.
What do you want? What do you want?
My lord, up 8, my lord, 7/8 December. Oblige, my lord.
My Lord, I beg to mention one review petition, my Lord.
You mentioned before the chief.
My Lord, I may be allowed to pass over for the day, my Lord. I will file, my Lord, implement.
What is your name, Mr.?
Just a moment.
Mr. J. Islam Counsel for the petition submits that the petitioner has expired during the penance. Accordingly, he may be allowed to implement the legal years of the petitioner to pursue the matter. He is allowed at least after a month. In the meantime, you file application.
Lord, another matter, my Lord. Item number 28, my Lord.
Item number?
28, my Lord. I am on behalf of my Lord R. Sudhuri. He is on Lake, my Lord. Matter will pass over the day, my Lord.
Who?
Miss R.
Rajani Bhaumik.
R. Sudhuri, my Lord.
Okay. Admission. What is LCR is there? What is this matter? We'll fix for hearing.
He is on Lake today, my Lord.
Who is on left?
R. Sudhuri, my Lord.
R. Chaudhary. Miss R. Chaudhary. Anyway, she's on lake. She will be late throughout the day. Let her come and we'll see that. Because if it is list to be listed for we'll list for hearing. Huh? Okay. Yes. Yes, Miss R. Chaudhary, you are no, she also on lake here.
Make me lawsuit.
What do you want? This LCR has come, so we can fix for hearing then.
Yes, Lordship, only for today, your Lordship, any other day, Lordship. Hearing column in any other day.
It will come up some other day.
Lordship.
Okay, on the priorities, this for hearing. Since the records have been issued, the matter will stop for hearing. Yes, next.
May please, your Lordship. Millet item 24 in admission column, your Lordship, with LCR, your Lordship. Maybe taken in some other day, your Lordship. Today,
List for hearing. Since the records have been issued, the matter will list for hearing. Yes, next.
Item number 23. When LCR has come,
You want to go home? You want to go home now? You want to mention it? We'll call serially. You want to go home now? You want chutti? List. You wait for your turn. Everybody is coming. Yes, next.
Daily list promotion item number 1.
Khairun. Yes, records is there. We'll list for hearing. Since the records have been received, yes.
Is under res judicata, my Lord. Once, my Lord, she was declared an Indian, my Lord.
But have you file? Register.
My Lord, page number 28, my
The
Lord.
records have been received, no? We have called. In which
Page-
case? In
page
which case
20.
he was?
Page 28, my Lord.
Page 28.
28, my Lord. This order was also exhibited, my Lord.
Then what is the learned tribunal say about this, Res Brigada?
This was exhibited, but this was not considered. my lord.
Where is it? Order. What does the learned tribunal say? In
My
order,
lord, was 47, my lord.
page 47. What is the learned tribunal say about this?
My lord, page 50 below part lordship. Exhibit 9 is the order copy of the Sonitpur declaring Masamat Kairun Nisa, wife of Siddiq Ali, Thilis, Berazan PS Tezpur district Sonitpur. Assam,
Exhibit-
Indian citizen.
Exhibit 9, huh?
Yes,
My-
yes, lordship.
Order of
Page
so
50.
and so is Indian by the state foreign servant. The order of foreign servant one cannot be accepted as a profound principle as it can be said the same party due to difference of village which cause difference address. This all belong to village Berazan, but the reference made to Singtali village. Moreover, has not proved the order of foreign servant by examined officer FT. Huh? FT officer will examine the FT. Mr. Sharma. He'll examine the presiding officer FT. And they will resign. They said, you'll call this FT officer to be examined. Huh, Mr. Sharma? You go reconsider it, reconsider it. But different village,
Shifting, my lord.
Yes, lordship.
shifting. Have you
Shifting.
explained in your written statement that it was
My lord, my lord, my lord. Yes.
okay. Mr. Sharma will remind it, let it be reconsidered. Otherwise, if you ask the tribunal to come, then they will say that, oh, hard Mr.
Yeah, Ali.
Counsel for the in the petition challenged the impugned opinion dated 22/10/2022 passed by Lane page 47 by which the petitioner having declared him a foreigner. Petitioner submits that though the petitioner had taken that raised the plea of res judicata on the basis of earlier opinion rendered by the foreign tribunal in Senso exhibit 9, huh? Just check up, huh? Senso. And the Lane tribunal had declined it on the ground that that villages are different, and also the office of the office of the FT Sonipur would be required. Concern officer of the FT first Sonipur would be also required to be examined. Full stop. It has been submitted by Lana Council for the petitioner that the difference in the village is because of shifting, which have been also mentioned in the pleading. If that is so, the FT the tribunal ought to have considered that aspect also. Further, the tribunal it was further tribunal also as regards if as full stop if the did you file a certified copy or just the copy? FT earlier FT just the copy.
Certificate
Photocopy.
copy, certificate copy, my lord.
Huh?
Certificate copy, my lord.
Certificate
Certificate copy. Yes, ma'am. Page number 32, my lord.
You filed a certified copy.
Yes,
Let
ma'am.
us see. Let us see.
32.
Just a minute. Just. Is a photocopy or certified copy or certified copy? Let us see. What is the earlier opinion?
Earlier opinion, page number 32, vernacular, my lord.
Compare with original. Okay. Further, from the record, it appears that the copy, earlier opinion, copy of the earlier opinion dated 23/11/2015, huh?
My lord.
Was filed before a tribunal which was compared with the original and was exhibit 9. And as such, if the original was produced, the question of examining the concerned authority of the FT foreigners tribunal may not be necessary except for the petitioner to prove that it is a certified copy of the certified copy of the order. And the certificate of the opinion, full stop. If the petitioner is able to prove that the petitioner was indeed the person was proceeding in the earlier FT case number so and so, he can make a legitimate claim that the present petition is barred by res judicata. Full stop. And as for the proof of the certified copy of a certified copy of order, it goes without saying that if it is a certified copy, the examination of the concerned officer may not be necessary, of the FT may not be necessary. Be as it may, we have the view that this matter would be required to be re-examined by the FT for the reason that the foreign tribunal had rendered opinion against the petitioner by rejecting the plea of the principal res judicata, full stop. Under circumstance, without going to the, without going to merit of other grounds raised in this petition, we allow this petition by setting aside the impugned order dated so and so, and remand a matter to learned FT for reconsideration, especially on the plea of res judicata raised by the petitioner. That learned point, after hearing the petitioner, will pass a fresh opinion as regards the said issue of res judicata, and pass appropriate orders, full stop. It goes without saying that if the tribunal rejects the plea of the res judicata, the petitioner would be entitled to challenge the said opinion, including on the grounds, including the other grounds raised in this petition. With the above observation, the representative dispose of the petition will appear for the tribunal within a period of 1 month from today. Yes,
Earlier opinion was passed by different tribunal. Lordship. Earlier opinion was passed by different, not same.
no problem, whatever it is. If he's able to show that he is the same person,
Then
then next.
Item number 2.
Jafrul Khatun, yes.
My lord, my submission, my lord, there are several law points involved in this case.
So we'll hear then, list for hearing on so and so.
Some protection kindly be provided.
What protection you want?
Yes, because police is behind me, my lord.
Behind you.
Yes.
But
Dorang,
the police will protect you.
if your lordship protect, then only.
You-
Lordship,
Eh?
If your lordship protects only, then only police will protect, otherwise not. So many law points are involved in this case, my lord. I will argue on those points in appropriate time.
Jarbul Khatun,
Yes.
how old is she?
after dismissing of the review, Lordship.
Anyway, how old is she, this
She
lady?
is, my lord, now 50 years.
Oh, 50 years, don't arrest her. Or in the meantime, the matter will be listed for hearing. In the meantime, the petitioner Jafrul Khatun, alias Jafrul, if not detained, may not be detained and deported. However, she will be allowed to, she'll appear before the SP Borders. SP Borders?
And put Dorang at Mongoldi.
On punishment bond.
After dismissing of the review petition, Lordship, upon some same cause of action, Lordship, is
Huh?
this petition is liable or not, Lordship, maintainable or not, Lordship? There
We'll
is-
examine, we'll hear all those low point. Next,
Item number 3.
Dipti Das, yes.
My lord, petitioner has been declared foreigners
so?
post 1971 still.
How do you say you're Indian? How do you say you are Indian?
Yes, but I have exhibited documents
Which,
to establish the citizenship of my parents. I have exhibited the voter list of 1966, 1970 and two sale deed of lands.
Then what is the Learned Tribunal say?
Learned Tribunal discarded all the evidence on the basis of extra legal speculation, irrelevant speculations, my lord.
What extra legal speculation?
Your lordship will find the opinion at page 118. But the relevant part where exhibit 1 is dealt with is 122, my lord. It's page 122. Exhibit 1 is a copy. I'm reading out. Exhibit 1 is the copy of the voter list of the year 1966. I found there is no issue number in the copy. The signature of the copyist and comparer are seen without their respective seals. Here it is seen that the copy is certified by the electoral registration officer LA 14 Borhola. The electoral registration officer LA 14 Borhola is
Okay, notice record interim.
interim, my lord.
Yes.
Obliged.
Item number 4.
May please lordships. Is this, my lord, the impugned order, my lord, at page 111, my lord. Page 111.
What is wrong with
Say
that?
examined, my lord, the petitioner herself examined as DW1 and her elder brother, my lord, as because her father was died much more earlier, my lord.
Okay, notice
70.
record interim.
Much.
Item number 5.
Bulidas,
Expertly order, my lord.
expertly, what happened? Why did
Notice
you
not
go?
served to the petitioner, my lord.
Not serve. How do you say not serve?
My lord, equally petitioner residence, Bilashipura ward number 3, my lord. The said place was earlier in the ward number 1, my lord.
Where is the notice? No, we have not annexed a copy of the notice.
Report was page 25, my lord.
Page 25, what did he say? I have visited venue mentioned, came in local one, Anganwadi center. Ah, there's a whole problem, no? You can't put in Anganwadi instead. If you had put in the earlier, then Anganwadi center, to children will stay there. Women will not stay there. Har Mr. Lana come, brother will dispose them. I will go there, appear before travel. Har Mr. Lana comes, brother Krishna, Lana comes, the concerned nature of the case, we are inclined to allow this in at this stage without issuing notice to respondents. The petition have been, the opinion has been rendered on 13/3/2020 ex parte against the petitioner declaring her to be a foreigner of foreigner. What stream?
After 1970, post 1971.
Post 1971. It has been submitted that the petitioner was never served with a copy of the notice issued by the tribunal as such. She was aware of the proceeding before the tribunal as such. She could not appear before tribunal and accordingly the said ex parte order has been passed. So we have in support of the claim that she was not served with a copy, we have gone through the copy of the petition which has been annexed, copy of the notice which has been annexed in the petition. Perusal of the notice indicates that the process server has mentioned in his report that while visiting the village he did not find the proceeding therein, and accordingly notice could not be served. Accordingly, the copy of the notice was affixed in the Anganwadi center of the village after taking signature of the ward commissioner and VDB. We are of the view that the aforesaid method of service of notice upon a person who is not available, because is not contemplated under law. What the law contemplates is that it should be served, it should be pasted on a conspicuous place, in the place where the proceeding noticee was stated to be last residing, or in absence of which the notice should have been referred to the concerned district where the petitioner would be staying. Be that as it may, since law does not contemplate service of notice by pasting on the Anganwadi center, and since the petitioner has appeared before this court seeking to challenge to prove that she is an Indian, not a foreigner, and thus seeking to contest the claim of the state that she is a foreigner and not an Indian, we are inclined to allow this petition by setting aside an impugn ex parte order, so and so, and allow the petitioner to contest a claim by appearing before the tribunal by filing a written statement and necessary documents and adduce evidence before the tribunal. Accordingly, the petitioner will, after having set aside this order, so and so, the petitioner will appear for a tribunal on or before 1 month, give a date, so and so, a tarikh did 1 month, so and so. In the meantime, the petitioner, during the penance, however, will be allowed to remain on bail, subject to her appearing before the SP border. Dhuri, 5,000 security. Fingerprint for mobile phone. Do you have mobile phone?
Yes, ma'am.
Buy a mobile phone. Give a mobile phone number to the. Yes,
January.
Publish.
2nd of January. Item number 6.
Abdul Rashid.
My lord, hearing this case, my lord, petitioner is challenging the proceeding. Lordship, may kindly have a look at the notice at page 47. My lord, he is hailing from Nagaur district. He went to Shivsagar and for work, and his name and address has been taken, and this case has been registered, my lord. The petitioner's contention is that his defense at the investigation stage has been denied by.
Right now, is it going on?
My lord.
Right now, the proceeding is going on.
Well, yes, my lord. The notice, my lord. He has been served notice, page 47, my lord. My lord, my prayer is that this proceeding is illegal. It should be set aside. If any proceeding is to be done, that should be through investigation locally and in his own home district, my lord. So, my lord, at this stage, my lord, record may be called for of this case, my lord.
You mean to say there was no investigation?
No investigation, my lord. I have made a specific statement in paragraph 8. No fair investigation. Police has simply taken his name and address and this case.
Okay, we'll call for the record. Notice record interim.
Deeply obliged.
Item number 7.
May I play Lordship? Lordship, my father appeared Lordship in this case.
Father appeared.
Lordship.
Notice record interim.
SP Dorang Lordship.
Item number 8.
Yeah, Lordship, in this case, my lord, tribunal has traveled beyond jurisdiction, my lord. My lord may see the, maybe seen the notice, my lord, page 35. Allegation was that she is a illegal migrant of 1966 to 71. But she has been declared for 71 stream, my lord. Page 35, my lord.
Notice
Barnett.
record interim.
My lord, she is in jail, my lord, detention.
In a minute, Learned counsel submits that the petitioner has been retained on the strength of the ex parte order dated so and so, so and so. It has been, it is a case of the petitioner that though the proceeding was initiated against him on the ground that she is a foreigner foreigner having entered India during the period of 1/1/1966 to 1971, the learned tribunal gave the opinion that she is a foreigner of post 25/3/1971 stream. They have been submitted in a number of cases. This court has held that the tribunal could have given a different finding contrary to the reference sought for. More so here when the matter was proceeded ex parte. Full stop. And we are prima facie satisfied that the opinion, ex parte opinion rendered by the learned tribunal can be sustained in law. As the tribunal could not have given a different opinion, which is not in accordance with the reference sought for. Under the circumstances, we are of the view that the petitioner, while considering this petition, the petitioner may be will be entitled to remain on bail. According to the petitioner, will be released on bail on condition 5,000 security letter amount so and so.
Highly understood.
SP border?
Dorang, my lord, Mongol.
Yes. Next.
Item number 9.
Moran Mazumdar. What happened to you, Moran Mazumdar?
Pleasure, Lordship. Lordship, in this case, the petitioner declared foreigner post of 71, my lord. Page 40, my lord, and
Yes.
8, my lord.
Yes.
Then after, my lord, earlier represent, my lord, in this petitioner declared Indian.
India?
Indian, my lord.
Indian. So ex parte.
Yes, no obstructing, my lord, contested case, my lord.
Indian earlier it
Earlier
was
Indian, my lord.
Indian, it was declared. So res judicata, you mean to
Red
say.
judicata,
On Mr. Lana issue notice so and so. The case of the petitioner is that the present impugn opinion is hit by a principal res judicata in the petitioner was earlier declared to be Indian white opinion dated so and so, so and so. Understand that call for the records in respect to the FT case number 1 and 2, earlier also, In the meantime, the petitioner may be allowed to remain on bail. SP border?
Punitpur, my lord.
Item number 10.
Chand Ali, Chand.
My lord, I have been declared as foreigner of post 71, whereas I have every document since the year 1966 onwards. And I also adduced evidence of my brother with whom my name also appears.
Brother, your brother, own brother, real brother.
One brother has been examined by
One brother means how many brothers you have?
that is not here, but cyberly examined and that is recorded with me. And in the statement also I have given, and the impugn opinion was mainly on the ground that there are differences in the names and address, and I have no house. That is the inquiry. But notice was sent to me in my house, and I received it and I appeared, I submitted WA.
No, you may be staying in a rented house, not your house.
No, own house.
Your own house.
I have own house. Own house, but the tribunal inquiry officer said that he has no house. But whereas in my address, my notice was sent, I received it, I appeared, I submitted
But there
WA.
are many people who stay in the boat also.
But I am not one of them, my lord.
Notice record interim.
SP Bongaigaon.
Yes, no.
Nice, my lord.
Item number 11.
Meena Bibi, yes.
My lord, I have been declared to be foreigner, my lord. My own mother has been examined,
Own mother,
my lord.
your own mother,
My own mother.
not stepmother.
No, my lord.
Okay, notice record interim.
Must apply.
Item number
SP
12.
border?
Dhubri.
Dhubri.
Item 12.
Jamaluddin,
Prisoner has been declared foreigner, imprimed order, page 29.
what is wrong with that?
Wrong with my father's name appeared in 1959
Then,
and 71.
And also number 66 is not appeared. There is a shifting minute, so my father and mother name did not appear in 66. And again, my name, my mother name, brother name, father expired.
Anybody who was examined, who has given evidence?
I myself mirrored and on my cousin,
Cousin.
elder brother,
Huh?
cousin.
Cousin is what? What does everybody is a cousin in this country.
Father's brother's son.
Father's brother's son. Real brother, father's real
Yes,
brother.
yes. There are two brothers and we are three brothers.
Notice record interim.
SP Golpa.
Item number 13.
Hasnara Begum,
Yes, my own elder brother has.
own elder brother.
Yes, my lord.
How do you say he's your own elder brother?
Elder brother, which is at page 42, my lord.
Page 42.
42. The opposite party is my own younger sister.
Opposite party is my younger sister.
Yes,
And no cross examination.
yes, correct.
If you don't cross examination, if you don't cross examine, then he becomes a brother. Then anyway, then not record interim. Yes,
SP Dorong, my lord.
Item number 14.
Muslima Khatun.
May I please your lordships? My lord,
आगे वाला record, notice record interim. Yes, Muslima Khatun.
may I please your lordship? Here, my father has deduced evidence.
Father?
Yes,
Your own father.
yes, own father, not projected father. And my headmaster of my school where I studied,
Notice record interim.
deeply realized, Dubri lordship.
Huh? Sorry? 14. 14, na?
Yes, lordship,
Nobody ESP board.
deeply realized.
For admission, item number 15.
Notice, since the records have been received, the matter will listed for hearing?
Lordship will kindly fix the matter in the first week of December.
No.
Because,
Yeah.
may I have a prayer, my lord?
Yes.
My lord, the biological brother of the petitioner, my lord, he is declared to be an Indian citizen, my lord. I have,
Biological,
yes, my lord, the own brother, my lord. Same
biological,
tribunal.
we are hearing biological, geological, historical.
My lord.
Real brother, you mean to say that?
My lord, my lord. I have, my lord, submitted the additional affidavit also, my lord. Bringing to record, my lord.
So what your biological brother has been declared Indian, so what? You
My
may
lord,
be
the
a
basis of
foreigner.
Same documents that were exhibited before the same tribunal, my lord.
Okay.
Same documents, my lord.
Second week of December.
Lordship will kindly fix the date.
Yes, next.
13. Item number 16 for admission.
60, what is this?
Lordship, we could not file a written statement.
You also, what is this? You know, what is
Lordship
this?
is against the judgment and order 35/2017, whereby we were declared as foreigners, my lord.
Been declared foreigner.
Lordship, because Lordship, we could not substantiate any,
Pronoid
could not give
date.
any evidence.
You
Our
are also
counsel could-
Bangladeshi, No.
Because non-submission and WS, my lord.
non-submission.
Lordship, an opportunity be given to us, my lord.
Yes, Sharma. Let them, they say that Pronoid day. And
Pranay
you,
Day, Reena Day, Prabhakar Day.
otherwise you are Indian or
We
you
are-
came
we
from
have
Bangladesh.
documents, Lordship, to that effect.
You
We'll
came
subs-
from Bangladesh taking shelter or you are originally Indian?
Lordship,
Identity card. Oh, you have come from,
Yes.
I think, Bangladesh, no?
Pakistan.
Family 10, camp registration.
Lordship will,
There, I think they escaped Bangladesh, is Pakistan, because the identity card says camp registration, camp. Let them be examined. This is
No, it-
1969,
oh,
64. So they have come before 66. Identity card.
Lordship.
And what did the learned tribunal say?
Lordship, because non-submission of
Written
written
statement.
statement within the stipulated period, your Lordship. We have exhausted all the dates.
In the present petition challenge the order dated 35/2017 passed the learned FT Morrison in FT case number so page 26, by which the petitioner and other members of the family have been declared to be foreigners of post so and so. Yeah,
Yes, yes, my
post.
Yes,
Where is it? Post 25/3/1997 stream. It has been submitted at, unfortunately, though the petitioner has been submitted, though the petitioner received notice and
we appeared.
but could not file the written statement on account of the because they were busy in collecting the relevant documents. And
No, like our contention is that our council did not file it. Lordship, I'm sorry to say. Lordship, one opportunity be given to us, we'll.
this,
I'm sorry
fine,
to
what
say
to do
that.
with this council? What to do with this council who are appearing the foreigners tribunal? These councils, Are they counsel or what?
My lord, in that case, my lord, where the negligence of
Correct,
counsels may not be.
correct. Well, then these people, they, see, counsel, they are respected. Lawyers are respected in this country, you know. In this country, the, in our, when we got this independence, you know, the lawyers were leading. So there are a lot of respect for the lawyers. When the lawyers appear, then, oh, he's a lawyer, Ukil, Amar Ukil.
I obviously.
But then these lawyers, they nowadays,
My lord, but one thing, my lord, it is the case of the proceeding. It is her duty or his duty to, my lord, contact the lawyers.
correct,
What the lawyers can do, my lord, lawyers appearing there.
Layman, your lordship,
Without
they
fees.
don't have much knowledge about law and
much
process.
knowledge and much money
There
also.
is no other option, my lord.
Much knowledge and much money.
Yes,
Nowadays, see the fee we am told is astronomical. People are
Daily-
charging.
yes, daily fees, we cannot bear.
My lord, even in trial court, that daily hazira is 500 to 1,000. my lord.
So anyway, since let them, because it appears there are some documents to indicate it there, huh?
My lord.
There have been submittable unaccountable petitioners that though the petitioner were ready with the document, the lawyers did not file the written statement, because of which the matter was proceeded without hearing the petitioner on merit. Petitioner, petitioner otherwise had sufficient documents to show that they are Indians. In fact, there is documents of identity card to show that the petitioner has family, his family had entered India from Bangladesh, taking shelter in this country. Suddenly, as and to that extent,
Residential proof.
resident proofs are there to show to documents prior to 1966. And there are also other voters lists which show that they have been casting their votes regularly, and also in possession of properties,
Yes.
having purchased and that's have been submitted. There are great serious prejudice will be caused to the petitioner if the petitioners are not given an opportunity to appear before the tribunal and contest the claim that they are foreigners. We have also gone through the documents filed by the petitioners in support of which in support of the claim that the petitioners are Indians. Under circumstance, we are inclined to allow give another opportunity to the petitioners to appear for the tribunal to file a written statement and adduce evidence in accordance with law, and the learned tribunal, after considering the said evidence that may be adduced by the petitioner, will pass a fresh opinion as regards the citizenship of the petitioners. According to the presence allowed by sitting as an MP on so page 26. The petitioners will appear for the foreigners tribunal within a period of 1 month from today on on or before so.
2nd of January.
In the meantime, during the penance petition, the petitioner will be allowed to remain on bail, subject to furnishing a bail bond of rupees each. Subject to furnishing each of them furnishing a bail bond of 5,000 security amount. The petitioner will also appear for the biometrics, this iris, mobile phone also. Mobile number. Yes, next.
Item number 17.
If the LCI will receive, will fix for hearing.
Yes, my lord. My brother, my lord, Kaubura, my lord, it is evidence.
Very good, very good. You will be successful. Okay.
Second week, my
In the records, I will receive the matter will receive for hearing.
Item number 18.
lord, kindly, my lord, second week, my lord.
We'll see. So 2018, because we allow because it's 2017. It may be in third week, 2018.
My lord, interim may be continue, my lord.
Interview will continue. Yes, next.
Item 18.
Mamtaz, yes, we'll fix for hearing.
Could be passed it for some time.
Since the records have been received, the matter will receive for hearing. You're on bail? Huh? You're on bail or no? You don't have no idea.
But sure, actually, I have no idea.
You have no idea. Interim order paro or interim order is there. Yes. Since the records have been received. Next.
Item number 19.
Gazibur Rahman.
Yes, Lordship.
Records have been received. Okay, same order. Not hearing. Yes.
Item number 20 along with item number 31 of supplementary list.
Yes, records have been received. Okay.
I may be protected by interim order.
You are not protected.
No.
Huh? And you have been protecting yourself till now. Huh?
I file an IA.
IA. So since 2019, you have been protecting yourself.
File an additional affidavit and.
Fine. Since 2019, you are not interested. So don't, okay. It has been submitted, the petitioner has not been detained on the stand, the impugn orders, so they may be allowed to remain on bail. Yes, next. SP border. SP border.
No, my lord.
Same person,
My lord, same person, my lord.
Abdul Qadir.
Yes, my lord. IA is for the bail, my lord. IA may be treated as a disposal.
What do you mean by bail? You are in detention or what?
No, no.
Okay. Which one? Which one?
IA may
Oh,
be
in the
treated as a
supplement.
disposal, my lord.
I
Lordship has
dispose of.
granted bail.
I dispose of.
Keep law, my lord.
Yes, item number next.
Item number 21.
Jyotsna Begum, yes. Records have been received. Begum, record is received. Okay. Since the records have been received, the matter will be listed for hearing. Yes, next.
Item number 22.
Manwara. Manwara, yes, records have been received.
Petitioner is also on interim relief.
Interim relief.
Yes.
You have got it.
Yes.
So we'll continue.
Yeah.
In the records of medicine, the matter will be listed for hearing. Early interim order will continue. Next,
Item 23.
Jafar Jarifuddin.
My lord.
Will speak for hearing.
Yes, my lord.
Notice. Since the records of medicine, will move. Next,
Item number 25.
Sabia. Yes, so we'll fix for hearing.
Yes, there is no interim.
No interim.
Yes, my lord.
Huh?
No interim.
The police have not arrested you. Huh?
Not arrested.
Oh, you have not arrested her so far. Okay. In the interim, since the prison had not, if the prison had not been done on the strength of the suspension, page 32.
SP Board.
SP board,
SP Board.
Board, yes. Next,
Item number 26.
Anwara. Anwara Begum. Anybody for Anwara Begum? Bhor. Since the records have been received, the matter will be listed for hearing.
Item number 27.
Rafiqul.
LCR receipt, my lord.
Okay, same order.
Interim may be continued.
Interim will continue. Yes, then.
Item number 30.
Surya.
My lord, in this case, my lord, inquiry report says she is not foreigner, my lord, but.
Is it so?
She has been, yes, my lord.
Let us see.
Page 27.
We will see the original record.
And another aspect is, my lord, notice.
Just a
was
minute,
issued-
just a minute, just a minute.
My lord.
Format verification. Surya Nisa. Gwalpara. Serial number. Surya Nisa, how old are you?
At present, my lord,
Her name is in 1966. She speaks Assamese. Mother tongue also Assamese. Huh? And LBO report.
63 years.
Jaleshwar. LBO report.
Let it come for hearing, my lord.
Surya, she could not
We'll have to
produce.
examine it. Let it come for hearing. No,
Huh?
let it come for hearing, my lord. In the meantime, we'll go through the records.
But her name is in 1966
That's why, my lord, we have to go through the records.
and she speaks Assamese also.
Everybody speaks Assamese, my lord.
Isn't it?
My lord, another aspect is there. A notice was issued, my lord, saying that she is in between 1966-71, but declared as post 71.
So we'll declare you 66-71. You will be satisfied.
My lord,
Huh?
my lord,
Yes, fine. You see 66-71 again. You treat it.
Let me go through the records and, my lord, let the matter be fixed for hearing, my lord.
Okay, after 2 weeks.
my lord, similar matter fixed on 12, my lord.
Okay, 12.
There is no
Yeah.
similar
Okay.
matters, my lord.
Yes.
This will not be similar matters.
Yes, then next.
List over.
List over. Okay. No hearing fixed today. Oh, today is Friday. Oh. Yes, PP, you are ready? Says it appears.
My ready will not count.
Huh?
Your councils perhaps are not here.
No,
Otherwise-
count. Huh? It is a good day, Friday. Nobody is there, huh? The other side.
I met Brigita in the morning, B. Sharma, and she said that the other council, of course, is not there. She has one matter among a series of matters. She was otherwise ready, but
Actually, it's listed with other matter.
28 to
Oh,
30, she
series.
said. PJ Saikya was there. Whereas other councils, I don't find any. You hasn't it, no? Hasn't it, no?
Today you have seen the court's orders, so I don't know. They should take advantage of it. If they have 5 days.
They
No,
might come also thinking it will reach late, so they might come also, I don't know, but.
that is there any matter which is so old matter which is ready? If you are ready with,
Otherwise, those two series are gone for next week. And a few small matters are there, but councils again.
who is the council? Who is the council? Small matters, if you can dispose it of
Huh.
small matter,
Just Kiman?
any small matter,
Yeah, then, yeah. That's actually part two.
any small matter can be heard and disposed of.
Oh, I did.
Cause list to did you? क्या लोगों को did you cause list?
Sobur Mondal, that Sibopol is gone for next week, then
Yes.
Pradeep Bharali is disposed of, then Kiresa Tati, of course, is otherwise a small matter.
Hmm.
But then the, as Borgoha is not there,
Hmm.
Rontu Mahili is also there. He is also as Borgoha. And as Borgoha, I haven't seen him for long. Deepak Day was not well, much well. And then,
But we are told that Borgohain will come next week or something like that. I don't know.
oh, somebody called up.
I think next week, coming week.
Actually,
Then
they,
20th Raju Satnami. It was yes. They are all listed. No Satnami. We are all lit with
this is where.
Ajit Kumar is Mr. R. Dev.
Ajit Kumar, there was a report, I think, which went to the Ajit Kumar. The LCR was
Oh,
not
so yes,
here.
yes.
Ah.
Yes, Bizita, you are ready with any case. You take advantage of the Khali court.
Yes, Lordship, but that I 28 to 30. That
But then others are not there, no?
that is there is 28 to 30. They had also engaged a council. I have intimated him on that date also.
But if he is not here,
Yes, Lordship,
so
I need
you,
to.
any other case where you are ready, you can pick up from any of the list. You can go on the last day or last list also, if you want. The whole list is up to you. You can just pick up any.
No. Let's get one. These are repeats.
Any matter you are ready.
Corona matters.
Provided, of course, PP also has a file with her.
I was ready with that case, but today I have not think that it will reach. That is item 60. That I have not been, but I
60, Indreswar Bora.
the paper book is not with me, but 67 paper book is with me.
67,
Yes.
Sukumar Roy.
Yes.
Yeah, you have the paper book.
So Kumar Roy, I have. to
Just
check.
see,
It's okay. Otherwise, I'll see from the records.
Sukumar Roy. Let us see Sukumar Roy.
Lordship, but I have not gone to so.
No problem, we'll read because there is nothing. See, in criminal cases, all are based on evidence.
Yes, Lord.
Once we go through the evidence,
Yes,
we'll
Lord.
know where we stand.
That I can do, Lord.
Once we go through the evidence, we'll,
Otherwise, I'm ready with item 28, but.
others are not there, no? So others,
Yes.
if others are not there, then there is no point. Item 67, no? Sukumar Roy.
67, yes.
67, I have the paper book.
Okay, then let us see what is there. We'll go through the evidence.
Yes, God.
Can somebody there? We'll just dictate the evidence, then we'll see. It serve all our purpose, my purpose, your purpose, her purpose. Huh?
Yes.
We'll note down the evidence, then we'll know where we stand. Somebody there, yes. Present appeal, is it jail appeal? The present jail appeal has been preferred against okay, somebody will be there again. Judgment dated
5 to 14.
Present jail appeal has been preferred against judgment dated 5/2/2014 passed by learned session judge Kasa Silchar in session case number 36 of 2012, page 32, by which the appellant has been convicted under for commission offence under section 302 IPC and was sentenced to undergo rigorous imprisonment for life and pay a fine rupees 500. The prosecution case in brief is that on 4/9/2011, the appellant, who is a person with impaired speech and hearing, assaulted his elder brother Chandu Rai with a chopper within a dao, hitting him on the neck and thereby causing his death. Accordingly, an FIR was lodged. Exhibit 3. Lodged on four nine 2011.
Yep.
On the basis of the FIR, the first FIR lodged, arrest, a police case being Silchar police case number 1471/11 under section 302 IPC was registered. On the basis of the said FIR, investigation was launched. And on completion of the investigation, on being committed, the trial commenced before on committed and all on reading and on committed and charge with file which the charges being denied by the appellant. Trial commenced. In course of the trial, as many as 8 witnesses were examined by the prosecution in support of his case. The defense also adduced CW1 is a court witness.
Court witness.
Huh?
Yes.
So it is not a defense witness.
Yes.
Who is this court witness? Case 25.
W1 Jayanto Kolita 2526.
One court witness also examined
That is because of his deaf and dumb person, not for
relating to the issue as to whether the petitioner was a deaf and dumb as claimed. To stop. The learned trial court, after considering the evidence on materials evidence on record, felt that the prosecution has been able to prove the case beyond reasonable doubt against him, against the appellant, and accordingly convicted the appellant under section 302 IPC and sentenced him to RI for life as mentioned above. In view of the submission advance that it cannot be said that prosecution has been able to prove for charge beyond reasonable doubt, will proceed to examine the evidence on record. Next one. One Purimol, who is this PW1?
He's the nephew.
Nephew.
Nephew, who had gone to cut the hair of the deceased. He's
PW1.
an eyewitness.
PW1 is one Purimol Roy, an eyewitness, who stated that the occurrence took place on 4/9/2011. On the said day, at around 2 p.m., the deceased Chandu Rai called him to his house to cut his hair. There he found Chandu Roy cutting bamboo, and accused was standing there. The accused was unable to speak. He then by gesture asked the PW1 to cut the hair of Chandu Roy. While he was in the process of cutting his hair and went and left to take out his razor blade to complete the hair cutting, he saw the accused giving a dowel blow on the neck of the deceased. Thereupon he raised a hue and cry. Then the accused also tried to give him a blow with dowel, and out of fear he ran away from the place of occurrence. Upon hearing the hue and cry raised by the PW1, people gathered there, and after some time he came to the place of occurrence. Thereafter the police also came, reached the place of occurrence and recovered the blood-stained dowel from the bamboo bush and seized the same, to which he put his signature as a seizure witness. He also stated that after about 25 days of the occurrence, his statement was recorded before the magistrate, which was also proved before the court. Since he was the eyewitness, he was subjected to thorough cross-examination by the defense. In the cross-examination, he of course stated that he did not know if there was any quarrel between the accused and deceased. But he stated that he found that there was a cordial relationship between them and that he did not hear of any quarrel between them. He also stated that the deceased and accused resided separately, and he also stated he did not know whether there was any partition in respect of land between the deceased and accused. He also stated he was related to the accused as well as to the deceased. He also stated nobody had informed him that the accused was suffering from mental disorder. He denied the suggestion that he, along with one Chandu, who is this Chandu Roy? The deceased, huh? He, along with the deceased, had tried to evict the appellant from his residential house because of which by assaulting him. And he also denied the suggestion that when he and the Chandu Roy wanted to assault the accused, suddenly the dowel blow fell on the deceased. He also denied that he had falsely accused the appellant of killing the deceased. The next witness examined was one Nomita Roy, who was the daughter of the deceased Chandu Roy, who stated at a time of occurrence she was sewing clothes in her house, and his cousin Porimal Roy, PW1, was cutting the hair of her father. Then his father asked her to go inside. Suddenly, PW1 started shouting and came running and told her that the accused has cut her father. And then he came to the place of occurrence and found her father lying dead with cut injury. Thereafter, people also came to the place of occurrence. The elder brother of her father, her uncle Pavitra Roy, the elder brother of her father also came there. No, Pavitra Roy, who is this Pavitra Roy?
Informant,
Okay.
brother. They are all brothers. They are all-
Okay. Okay, he informed, yes, he informed the Pavitra Roy, the elder brother of the uncle, her uncle, that is the elder brother of her father, about the incident. She stated that when she came out of the house on hearing the shouting, she saw the accused person running away and throwing the dove in the bamboo bush. She also mentioned about the recovering of dove from the bamboo bush. She was also cross-examined by the defense. And denied that she was influenced by the PW1 and her uncle, and had deposed falsely. Next. The next witness examined was Pavitra Roy, who was the elder brother of the deceased. He stated he resides in a separate house, and on the day of occurrence at about 2:30 p.m., while he was in his house, he heard a shouting from the house of the deceased. Whereupon he went there and he saw the deceased, the accused Porimal. No. Porimal is the brother, no? Porimal Roy,
He's the nephew.
nephew, no? And he saw the Porimal, PW1. Porimal is PW1, no?
Yes, sir.
Porimal running towards his house. And he asked him as to what had happened. Then he informed him that the accused Sukumarai had killed Chandu Roy. Thereupon he arrived at the place of occurrence and found the deceased found Chandu Roy lying dead. However, he did not find the accused. He then raised a hue and cry. And thereafter, Porimal also arrived. He then informed the people who gathered there. The villagers then apprehended the accused persons. Thereafter, he lodged the FIR with the police. He also witnessed to the inquest conducted on the dead body. In a cross-examination, he stated after hearing the shout, he came running to the place of occurrence and found Porimal, PW1, running away, but did not find any other person there. He also stated he had not seen the deceased and the accused fighting with each other, and that there was a cordial relationship between them. He also stated the accused was loyal to the deceased Chandu. He also stated that the accused, since his childhood, could not speak. The next witness examined was Khelon Roy. Who is the elder, who is also the elder brother of the deceased. He also stated that accused Sukumara Roy is his brother. He also stated that the accused was unable to speak since his childhood. On the day of occurrence, he had gone for work in the Anchalik Panchayat, and while there he got a call over the mobile phone that an incident had occurred in his house, and thereafter he went there and learned that the accused Sukumar Roy had cut Chandu Roy. Thereafter, the Anchalik Panchayat member informed the police. He found, when he came to the house, he found, no, who is this Nomita?
Nomita is wife of,
Okay,
Nomita is daughter of deceased.
okay. He found Nomita, the daughter of the deceased, in an unconscious state. He also witnessed to the inquest conducted on his body. He also stated the police recovered a dove from the bamboo bush. However, he denied that. However, he stated the accused was not mentally unsound. In a cross-examination, he also stated he never saw any quarrel between Chandu and Sukumar, and that Sukumar was loyal to the deceased. He admitted that he was an eyewitness. He did not see the occurrence. The next witness examined was Dr. B.C. Roy Medhi, who conducted the post-mortem examination on the dead body, who found the following injuries, page 19. 1. And according to him, the immediate death resulted from the cut injuries sustained on the neck and chest, which were ante-mortem and caused by heavy, sharp cutting weapon and homicidal in nature. The next witness examined was PW6 Chandana Roy. Who knew both the deceased and the accused. She stated that on the day of occurrence at about 2 p.m., she along with the daughter of Chandu Roy were working inside their house. At the time, Porimal came running to her and told her that Sukumar Roy had cut Chandu Roy. Thereafter, Porimal went running towards his house, and the accused also chased Porimal with a dove in his hand. At that time, she heard shouting of daughter of Chandu Roy, and on hearing the shouting, she went to the place of occurrence and saw blood stain at the place of occurrence, and saw the head of Chandu Roy was shivering. She then saw Kokuli Roy. Who is Kokil Roy? Kokil Roy? She saw Kokil Roy bringing a bucket of water, and then she fainted. Kokil. Who is this Kokil Roy?
PW7. He came,
Okay.
give water.
Kukil Moni Roy.
She show
Yeah, Kukil Moni.
Kukil Roy bringing a bucket of water, then she fainted. When she regained consciousness, she saw police and saw the dead body being taken away by the police. She also stated that the accused is not suffering from mental abnormality. The said in the cross-examination, she stated the accused Sukumar is her brother-in-law, within bracket, the younger brother of her husband. She also stated she did not see the occurrence herself. In the cross-examination, she admitted that she did not see the occurrence herself. Next witness examined was Kukil Moni Roy. She stated on the day of occurrence at about 2 p.m. while she was returning from jungle with firewood, and taking a bath in the pond, she heard a shouting in the house of Chandu Roy. And on hearing the shouting, she went to the house of Chandu Roy and saw Chandu Roy lying on the ground with bleeding injury on his neck. She then poured water on his head, and he was already dead. On being asked, Nomita Roy, the daughter of the deceased, reported to her that the accused Sukumar Roy had cut Chandu Roy with a dao. She also stated that the accused is not mentally unsound, only that she cannot hear and speak. The next witness examined was Anjan Chakraborty, who was the sub-inspector of Dharwar, Duarbon PIC. No, he was work under SI Pawan. Who is this? Anjan Chakraborty. Who is this Anjan Chakraborty?
Statement of under 161.
Oh.
IO is the IO.
He's the IO. The Anjan Chakraborty, who was the IO of the case.
Paramananda is it?
Huh? He's the IO? No.
He's not, he's a SI, but I think someone else
He's the
investigated.
only investigating officer that was examined.
One Anjan Chakraborty, a police personnel who was who was examined to testify about the investigation conducted by the IO, though he himself did not examine any witness.
Because the IO died.
Oh.
I recorded the statement under 161.
No, but he said, no, I have not examined the witness under 161, page 24. He did not examine.
He had no personal knowledge
Ah.
about the occurrence.
I was not present at the time of seizure. The other witness, Anjan witness, the next witness examined was Anjan Chakraborty as PW 8, who was a police personnel who testified about the entries in the case diary. I was familiar with the IO of the case, familiar with the handwriting and the signature of the IO of the case. And the various documents prepared by the IO of the case. From the cross examination, evident that he was not the IO, inasmuch as he did not examine any witness, nor he visited the place of occurrence. And he also clearly stated he had no personal knowledge about the occurrence. And he was not entrusted by the OC to investigate the case. The said, the court has been informed that the said PW8 was examined as the IO had expired. The court also, after conclusion of the evidence, recording evidence of the prosecution witnesses, the court also examined one Joyento Kolita as court witness, who was serving in the deaf and dumb school Guwahati as a special educator. To act as an interpreter, was appointed as an interpreter for Sukumar Roy accused, who was a deaf and dumb. He testified that he had observed his gesture by which he responded to his queries and found that he is able to understand what is conveyed to him by way of gestures, and that the accused can write his name in Bengali language. He also testified that he had explained the charge to him and he appears to have understood it. As the accused can write his name, the charge was written in Bengali language on a paper and shown to him, and he denied the charge. He indicated his denial by gestures of his head and hand, and also but wrote his name on the charge, which was exhibited as Exhibit B, which was a charge written in Bengali language. Full stop. Next paragraph. On completion of the recording of evidence of the prosecution and of the court, as mentioned above, the accused was examined under section 313 CRPC. To the question put by the court that PW1 had stated that on 4/9/2011 at about 2 p.m., when he went to the house of Chandu Roy, he saw Chandu Roy was cutting bamboo and he was standing there, and the accused by gesture asked him to cut the hair of the Chandu Roy. He replied that these are false, but he also stated that Porimol had given him a push. As regards the allegation that he had given a dao blow on the neck of Chandu Roy, he stated that it is false and he was taking meal at that time and he did not know how he died. As to the question that after PW1 seeing the incident raised the hue and cry and tried to run away from the place of occurrence, the accused stated that these are false and some other person had killed him and other people came and tied him up and beat him up. On the statement of the PW that people had gathered there and the other police came and recovered the bloodstained dao from the bamboo bush, he stated that 4 persons had come and one of them killed the deceased with a dao and threw away the dao in a bush. As regards the statement of PW2, he denied the same to be false, stating that he did not kill the deceased. He also denied the other statements, the statements of here all the allegation statements made. He also denied the incriminating statements made against him by PW2, PW3. However, he admitted that the villager had apprehended him. PW3 and PW4, huh? Incriminating statement. To the other questions put to him, he either denied as false or claimed ignorance. However, he reiterated that 4 persons had come and one of them had killed the deceased and that he was innocent and falsely implicated. Isita, what do you say now? With the evidence we have gone through, what is your case?
Lordship, the whole case is on the basis of PW1, Lordship. So evidence is that the deceased had asked him to come to cut his hair, but nowhere, not a question was asked whether there was any hair, because the evidence is that he had cut his hair and he went to take a razor blade only for trimming. That means that haircut has completed, Lordship. Nobody has said anything about whether any that cutting hairs are there, any scissor, nothing to that extent, Lordship. Some hair, after hair cutting, the parts of hair should have been there, Lordship.
Okay, suppose if it is not proved that he was cutting the hair, but at least the deceased, the accused did not say that Porimol was the one who killed.
Lordship, he
says his plea is that 4 persons
Yes,
came
Lordship.
and one of
4
them
persons
killed.
came. One
Then
of
if
them
then you could have identified.
that is an interpretation only, because he himself could not speak, Lordship. He is a deaf and dumb person, and from the evidence also, Lordship, there
Now,
is
Ms. Bizita, what do we deal with a deaf and dumb in a case? Have you done some research work on that? Suppose an accused is deaf and dumb,
Lordship.
even if mentally sound, because it is not shown by evidence that he was mentally disturbed
Yes,
or mentally unsound. Then how do you prosecute a deaf and dumb?
Lordship, actually they will not get any benefit because of deaf and dumb, Lordship. Because had it been a case of mental illness, then we have to show what kind, what
See,
is
the
the
fact
percentage
that
of
deaf and dumb means 2 things, either that he cannot hear, isn't it? He also can't speak.
Yes, sir.
That means he can't express himself properly. So what is that which is required to be provided to him so that he can defend himself properly?
For
See,
that, the
to-
court,
No, see, Vijeta, why we are asking is this. See, in a case, Supreme Court has held that if an accused is not defended by a lawyer, Supreme Court has gone to the extent of setting aside the conviction. Not because he was not provided with a lawyer, legal assistance. That will amount to denial of opportunity to defend. See, that is not a case of any deaf and dumb. He's a normal person also. He can shout, he can scream, he can say whatever he wants to the judge. He can deny. But even then also the Supreme Court says that if an accused is unrepresented, that will amount to denial of, see, fair opportunity to defend himself. A big thing. So if you compare that, when you are prosecuting a deaf and dumb who cannot hear, who cannot speak, what are the measures to be taken by the court or by the police or by the system to ensure that he is properly represented? This is something of, so what we do, Vijeta, do some research on that. See, as far evidence is concerned, Pure Porimol says he is the eyewitness. Okay, fine. And your plea that you just say also that no, the 4 people, these have been, they are all by gesture.
because one more thing, Lordship, if we go by the evidence of PW6, Lordship, our clear evidence is that the accused had chased the PW1 with a dowel in his hand. And if we'll go by the sketch map also, we'll see that the exit point from that place of occurrence,
Page number
page number 68 is the sketch map.
60?
68.
Yes.
That H is the entrance path to the that area, Lordship, place of occurrence, etc. And G is the house of Khelon Roy. Here is the spelling is written wrongly, Lordship. Khelon Roy G. And Khelon Roy is PW6 is wife of Khelon Roy. So according to her, I'm reading her evidence, page number 20. Occurrence took place.
Yes.
Occurrence took place about 1 year ago. I knew this is Sandhu Roy. I also know the accused Sukumar Roy. He is present in the dock today. On the day of occurrence at about 2 p.m., I, along with daughter of Chandu Roy, were working inside our house. Although Chandu Roy's daughter said that she was in her house, Lordship. At that time, Porimol came running to me and told me that Awa, that is the name of the accused, Lordship, cut Chandu Roy. Thereafter, Porimol went running towards his house, and the accused person also says Porimol with a dowel in his hand. Then if we'll then, Lordship, that G is the house sketch map and H is the entrance point. So he has to go by H, Lordship. In the sketch map, although house of Porimol is not shown. So if the accused had chased Porimol with a dowel, then again the Caesar said the dowel was recovered from the bamboo bush. That is D, Lordship. So how it again came? Who again brought it there, Lordship? So whether the same dowel that is he is carrying is the weapon of offense, Lordship? If he had seized with that, how it again came to that bush, Lordship? Because it's totally in a different way. D is the yes, D is the place where the shopper was
But
found
the
lying,
problem is that, see, the Porimol Roy is an eyewitness.
Lordship.
Has his evidence been able to been shaken by the defense? And interestingly, in the cross-examination, but there is another issue that there is no enmity between the.
Yes, Lordship.
So what is
There
the
is-
motive behind the killing?
There may not be what I
Sudden and grave provocation. If there is no enmity, It must be a sudden and grave provocation.
Provocation, there is nothing because as
nothing.
per the evidence, he himself told that now he will cut the bamboo. There is possibility is one that as he is a deaf and dumb person, what I could imagine that Lordship, he might have given a blow to Porimal because a few seconds ago he was there, Lordship, and he is a deaf and dumb. Perhaps he had not came to know that Porimal had left the place and his brother was there because he worked under Porimal. There may be some enmity between them.
He means this
This is work under Porimal and Porimal
Why is it?
there is evidence,
Yes,
Lordship.
there is evidence.
Yes.
Yes, I have seen that. Where is it?
This is page 21.
Page 21. The daughter of deceased accused Sukumar used to work under Porimal 2-3 years. Sukumar cannot speak. Sukumar used to reside with Chandu in the same house. But they are separate men. I never heard any quarrel between accused Sukumar Roy Chandu. There was cordial. Porimal has vast landed property, is rich person of our locality.
And why is Porimal will come to cut hair, Lordship? He is a rich man. And others say that they have he knows haircut. Only one witness says that he knows haircut, but others never ask him to cut hairs. He is a rich man. It's not his necessity to cut hairs to earn.
Porimal has vast landed property and he is rich person of our locality. A rich person cutting hair, and he is fond of cutting hair. There are some people, rich people, they have peculiar, interest in life. Some people like to paint, some people like to play golf, some rich person like to cut hair.
And the weapon was also
There
not.
are again contradictory statements at page 16.
Page
16 said, accused used to give service to Chandu Roy. This sounds more normal.
Did you see, what is it?
That page 16, fourth line.
The accused is to give service to Chandu Roy.
This seems to be.
What is this meaning?
He
what
works
service?
for Chandu Roy. Residing in the same.
Mess is different. Accused was loyal to deceased Chandu. Loyal.
All are saying there is a cordial relationship. between
Loyal.
Loyal.
Dosti.
And he is the eldest one, I think, the deceased. But in the FIR, they talk about quarrel over some PDS rice in the morning. FIR, Lordship will see, there was a
FIR.
altercation on that particular day.
Okay, we have not read the FIR properly. Yes, we'll see. Due respect, submit an altercation took place between the accused, my younger brother, and the younger brother of Sri Chandu, another younger brother of Chandu.
Over
My
matter of rice allotted. in
Chandu
the
over a
morning
matter of
hours.
rice allotted and the PDS in the morning hours today. So altercation took place between accused, that is my younger brother, and
The deceased.
another younger brother of Sri Chandu Roy over the matter of morning hours.
Another younger brother.
That's 4th
Another
September.
younger brother.
Another younger brother of Chandu Roy.
Pavitra Roy is a
There's no
brother of, all are from the same family.
So there's
All
no.
are same family.
Yes.
Three brothers.
Same.
Three brothers. And one of the brothers killed.
Yes.
That's all.
In fact, four brothers. One Pulin Roy is also there, although he is not.
The 4th at around 2 p.m., hearing a commotion in my house, my younger brother Chandu Roy, all of a sudden, I was rushing towards his house. I saw my nephew Porimal Roy running at the foot of Tilla, on which the house of Chandu located. Then I immediately called my nephew, asked him what the reason of the comment. He replied, he was cutting the hair of my younger brother Chandu Roy behind his Chandu's house. The above named accused arrived and killed my younger brother by hacking him on the neck with a dao all of a sudden, and the accused was fleeing to somewhere after hacking him. Having heard this, I immediately raised an alarm weapon and rushed and apprehended accused. Immediately informed Dharwal.
Apart from
This is
that,
a-
quarrel part is nowhere there.
This is a different story. Lord. Here, this bamboo cutting. This portion is also not there, Lord.
And what is the 161 statement? Let it, brother, we have a
Yes.
good.
161 statement I've read of Porimal Same statement. It's in Bengali. But a similar,
Same
same
statement.
statement.
When was the 161 statement recorded?
Oh, date I didn't see.
Here it's his 164 is here.
164 is also there, page 50.
Page
164 is page 50. Same corroborating statement.
One thing he had stated, I fell down and remained unconscious for a while. This part is not,
Who?
this
Porimol.
Porimal, this part is not.
At
in his
around
evidence.
so when I was home, Chandu Roy called me from his house to get a haircut. Whereupon I went to Chandu Roy's house. When I was going there, Chandu was cutting bamboo. On my arrival there, Sukumar Roy took a dog from Chandu Roy. Sukumar Roy said that he would cut bamboo. Sukumar asked Chandu to sit there and get a haircut. Sukumar Roy started cutting bamboo. I started trimming hair of Chandu. After that, after the haircut, I went to fetch the laser blade, which was kept over 7 feet away. Just then, Sukumar stopped cutting bamboo and dealt blow to Chandu Roy with a dao. The dao blow landed on the neck of Chandu Roy. Seeing that, I raised an alarm, whereupon neighboring people and the apprehended Sukumar Roy. I fell down and remained unconscious for a while. He fell down and remained unconscious. But he was chased.
Yes,
no?
Lordship, this part is not in his
He was
evidence.
chased.
Hmm.
People raised up and poured water on my head.
This
I
is
regained
not
my
there.
sense. And what about this? No villager was examined.
No other.
Who apprehended this?
No,
accused?
that part is not
All
there.
relatives.
Because he in his statement stated that he was tied up.
Ah,
But
but
how, and the more so, the weapon was also not sent for FSF.
and why these people came there? Why these people were not examined?
None
Yes,
of the
Jahan,
neighbors.
why
None
not
of-
examine all these people?
Yes, I'll just see the list of witnesses in the charge sheet.
We are a little bit concerned that the accused is deaf and dumb.
Hmm.
So, Bijita, see, if Supreme Court can set aside conviction and accused who is not represented by a lawyer, though he is represented, here it appears he is represented by a lawyer, but then I don't know. Was he represented by a lawyer?
Chief, I think legal aid counsel, maybe?
Legal counsel.
Yes, no, learned, no, state defense prosecution is also learned public prosecutor and state defense counsel. State defense counsel,
What's the defense counsel?
that is what is written.
A.K. Roy is there. So he's a lawyer.
A.K. Roy? Learned state
Yes,
defense counsel.
learned advocate, appointed as state defense counsel.
Perhaps legal aid.
Oh,
Hmm.
legal aid counsel.
I think 2022, there is a case of Supreme Court where it is said, I have not brought that. The procedure, he has to understand the proceeding. This is what is the requirement. He may be deaf and dumb, but he is not of unsound mind. So, but
Correct.
then the court has a duty to see whether he has understood the proceedings.
That's what, no? That's what we are a little bit concerned with that.
That judgment I'll have to see again. I found it in live law.
Vijita, I think please do some research for one day because this is a area of importance, significance, no? Because see, in any trial,
Hmm.
the accused must have all the benefit, facilities. Fair trial means what? He must be given all the opportunity to defend himself.
Yes.
That means he must be explained. And that, for example, like if you plead guilty, that itself is not, for example, confessional statement. And we have set aside so many cases. Confession, no, that the court did not ask this question, whether he understood, whether the court did not ask this question, it was voluntarily made or why did you, all those issues are there. These are technical things. Benefit of, not that to benefit, to give benefit, undue benefit, but these are basic rights of an accused. So if an accused is deaf and dumb, what are the precautions to be taken by the court?
That I know the duty cast on the court is
Ah.
to see
See.
whether he understood the entire
Correct.
proceeding.
And if he says that merely court saying that, for example, confessional statement, merely saying that, yes, I am satisfied that he made voluntarily. No, that is not enough,
Yes, yes.
isn't it?
Has to be
There are
shown.
so many,
Something more.
something more questions, specific questions about why you want to make this statement.
Yes.
Huh?
Voluntariness has to be
Voluntariness
seen.
has to be ascertained through the series of
Yes.
questions. So merely the magistrate signing that, oh, I found is a voluntary, will not do. So these are technical areas of law.
Moreover, Lordship will seek answer to question number 15 and 16 of the accused. This is something bizarre, something not
Page,
very.
page.
Page 30.
30.
Yes. 30. It seems he had seen the incident. 30 page, question number 15.
50 years. Pedro stated at the time hearing shouting Chandu and he went to play and saw blood and sends to the head of shivering. What do you say? The head was not fully severe. Chandana did not come to the
How
pure.
will he know?
Ah.
He was there. 16 also, Lordship will see Kukil said that occurrence at 2 p.m. He returned from jungle, went to the pond, he heard shouting. And wait, I do not remember if he came. So as if he was present at the place of occurrence. This shows whether he understood at all the questions, answers.
Father stated for report Watan Chandu Roy, but he was dead on being us. Nunta reporting that you cut Chandra down. What do you say? I don't know what was told to Kuki Moni by them.
But this is okay. 15 and 16 answer is little bizarre, little.
He is not of unsound mind, and
No, he is not of
evidence is that he, although he is deaf and dumb, he here is evidence.
PW 45 all state at time occurring, you are not mentally sound. It is false. What is this? Question 18.
You were not mental, it is false, Hare. So a doubt is cast whether he understood.
4 persons had come and one of them had killed the deceased. I am innocent. I have been falsely implicated. Will you adduce evidence? No. That's all. This quarrel between whom and whom? Not with the accused.
With
Quarrel?
the accused,
No, quarrel,
Yes.
quarrel.
there is no off. Lordship has read the word off.
Page 4.
For
An altercation took place between the accused,
That
this is
is
my
my
younger
younger
brother,
and another younger brother, Shri Chandu. He is
Chandu,
deceased.
over the, and another younger brother, Chandu Roy, over a metro rice allotted to PDS in the morning hours today.
Here, this younger brother doesn't mean the accused lordship, because
Ah.
PW4 is also another younger brother.
Another younger brother.
Yes, Kalon Roy.
বিবাদী অর্থাৎ আমার ছোট ভাই
হ্যাঁ।
ও উপর ভাই শ্রী চান্দু রায় মধ্যে বাড়িতে কাটাকাটি হইলে ইহার পরিপ্রেক্ষিতে আনুমানিক বেলা 2টা নাগাদ হঠাৎ করে আমি ছোট ভাই শ্রী চান্দু রায় বাড়িতে হাল্লা চিৎকার শুনি ও দৌড়াইয়া তাহার বাড়িতে যাইতে থাকিলে চান্দু রায়ের বাড়ির টিলা নিচে আমার ভতিজা শ্রী পরিমল রয় পিতা সোয়েন্সকে দৌড়িয়া দেখি আমি সঙ্গে সঙ্গে ভতিজাকে তাকে দৌড়াদৌড়ি ও হাল্লার শিকার সম্পর্কে জিজ্ঞাসা করিলে সে আমাকে বলে যে আমি আপনার ছোট ভাই চান্দু রায়কে তিনি ঘরে পিছন দিকে চুলি কাটিবার সময় উপরোক্ত বিবাদী এসে দা দিয়ে আপনার ছোট ভাই চান্দু রায়কে হঠাৎ করে জ্বলাইছে দিয়ে meaning both of them had a fight regarding
PDS time in the morning.
There is no difference in the
Yes.
in the-
FIR is not a substantive piece. There is no otherwise no evidence.
There is no difference to that effect in the question. What is the 164?
164 of Porimal is there, not
Yes.
the informant.
Let us see.
50, page number 50.
Not informed.
Not not Povitra's 164 is not there.
164, anybody had given, how many? Only one.
Only,
Only one,
here
only
only, in paper book only one.
That is not demoted.
164, only this Porimol run.
Yes, Lordship, but he had not stated anything about this informant Lordship.
Povitra's 161 can be seen. Povitra's 161. First page itself. His statement was taken at the first instance.
That information.
Informant. মাটি দাঁড়িয়ে কেন কেন Grievance sudden provocation
আমাদের এইটো story আর এইটো story একে রকম হয়। এটা বেয়ান পর
নহয় এটা different number কথা Perhaps in 161 also he has not said.
here they have stated
Lordship
that-
can also see section.
But then why should another brother implicate falsely another brother also? That is also there, no? Why
Section
should,
318 Lordship can see of CRPC. One has to understand the proceeding, not of unsound mind. Section 318 of CRPC. This was referred in the deaf and dumb case. The accused-
possibility of implication is there, Lordship, because out of them, 4 brothers, 2 had one died and he had only one daughter that deceased. And the accused, he is not married. So maybe because of property dispute, property.
But there is one statement that father has distributed the property properly. There is one, I got.
But then
somewhere.
also, Lordship, if the one died and the other will be in the jail for life imprisonment, so definitely they will enjoy. Possibility is there.
But he's unmarried.
He is unmarried.
He is
His part will be enjoyed by them only, the remaining 2 persons.
318 Lordship sees proceeding where accused does not understand the proceedings. If the accused, though not of unsound mind, cannot be made to understand the proceedings, if the accused, the court may proceed with the inquiry and or trial, and in case of a court other than a high court, if such proceeding result in a conviction, the proceeding shall be forwarded to the high court with a report of the circumstances of the case, and the high court shall pass thereon such order.
what is the circumstance of the case? What do you mean by circumstance of the case?
With
A result in conviction.
हाँ,
तो conviction हो गया तो appeal तो आ रहा है.
no,
We are
they
hearing.
did not. If it results in
Conviction. He has been convicted.
then
The proceeding shall be forwarded to the High Court with a report to the circumstance of the case.
this the court has to do. Here to appeal is by the
Correct.
convicted.
So
Reference needs to be made.
then the court has not made any
No.
report.
No, here to it's not a reference, it's a
Correct.
convicts
So
appeal.
the court has to make a report.
Provided the court feels he has not understood.
Understood.
For that, they have perhaps taken the CW1.
Maybe that is the reason they said CW1.
CW1's evidence we may read
Read
again,
again.
Lord.
Yes,
Page
please.
25.
I got my training institute so I get 6 years experience deaf and dumb. On being director principal Kahalipura, I have appeared today before a court to act interpreter who is accused. I have observed his gesture, I respond queries. Accused can write his name. He appeared only once.
Mhm.
He appeared only once. I have
Once.
appeared today before the court of
Yes.
session justice.
Huh.
For explanation of that sound, I think, not for other.
By the way, the accused in right name, on the request, I explained a charge,
Huh.
understood.
He
As
did
the
not.
accused can write his name, his charge written. He appeared only once or what?
Once.
Only once.
Only once.
Only
Will
during
it, will be,
313.
will it be sufficient?
Only during 313.
How does
Not
Mr.
313.
No, not 313.
During sound.
Charge, page 26.
Acha, I'll just read it.
And how does what is happening? And
As an
this
interpreter,
this
who's
advocate also expert or what? The defense counsel also expert. He will keep on interpreting by gesture.
Huh.
Because deaf and dumb, what is being decided, he doesn't know, then he will translate how?
Hmm,
Sign language.
hmm,
Does his lawyer also know sign language?
How can we say? Hmm.
Huh?
We cannot say that. of
I
course.
don't know. It will be good if a lawyer also knows the sign language.
State Defense Council.
State Defense Council.
I have explained the charge to him and he appears to understand.
That is for explaining the charge.
That is
Then
when,
after the charge, he understood, he denied. Then the evidence was late.
3/5/13, his evidence was recorded. 3/5/13,
Please.
26.
On the request, explain the charge. If the accused can write the charge was written Bengali, and he denied the charge, be the charge written Bengali.
3/5/13.
3/5/13.
The evidences were recorded later on.
Oh,
this is charge framing. This is
Yes.
that's framing.
Framing of charge.
Denying charge.
Evidences were recorded later on.
Then he made an
And-
assistant also during the course of
Hmm.
313 also required.
Very
And
good.
while the evidence also recorded.
He's always present.
Visita, do some.
Let us see on
Because
this.
accused
defendant.
evidence was recorded on.
See, we don't want a prejudice to be caused to an accused. Because that's the most important in a criminal trial.
Hmm.
The accused must not face any prejudice. Not only criminal trial, any for that matter, any proceeding.
Accused evidence was recorded on 9 January 2014. So almost 8-9 years later on.
And if he was not there, then the serious question, there is no also.
No.
And it can be a
Hmm.
visitor, do some.
Lordship.
Where is my assistant here, low clerk? They are not there. Oh, call them. They will be my assistant also. Call them, low clerks. Let them do some work also. But this is an area which we must, because see, in today's modern times.
Hmm.
Yeah, earlier times, different time, no? Medieval time, we don't know. Today, in this 22nd century, Nakiki, is it 21st? I don't know.
22nd perhaps.
Huh? Is it 22nd century?
21st. actually.
21st, still 21st, no? Now with this high tech and all this, and so much of importance given to the, of course, victim also there, but an accused also, they must be all afforded with all the necessary assistance.
Everyone is accused unless is proved. Not like
Yes.
France, I think everyone is guilty unless is proved innocent. So
So
we
here,
have a different system.
whether this lack of provision for any such assistance,
Hmm.
translators or, or interpreters, will it vitiate the trial? These are very important issue. Visita, I think this is something we would like to examine also. Because from the evidence, somehow there is something. You can't say what is it.
Hmm.
But see, as mentioned also by you, there's some inconsistencies here and there. I mean, and the fact that why other villages were not examined, why others who had assembled there, who are otherwise all, we don't say that just because the PWs are related, they are interested. We don't say that.
They seems to be natural.
They seem to be
Yes,
natural.
but, at least some villager who would have just said, no, you have reached and I have seen him lying injured.
And
That
we
evidence is
apprehended,
also not there.
and where he was apprehended.
Villagers had apprehended him, they said.
Ah,
He threw the dhow and left. No.
No, because the dhow, he says with the dhow.
And now but somebody said villagers are apprehended.
later accused chased out, and I saw Chanu shivering. I said, "Will Bhakpat after dead body." This Khelon Roy,
He was not there, but
No,
he is one of the brother. His wife gave the evidence.
The PW1, Porimal Roy, out of fear I ran away. The accused tried to give me a blow with a dhow. Out of fear I ran away from the place of occurrence. Hearing my shouting, people gathered there. Thereafter, I again came back to the place of occurrence. The accused person is not mentally unsound. He used to communicate with my gesture. Thereafter, police from Darwar came to police and recovered the bloodstained dhow from bamboo bush and seized the same. At about 25 days of occurrence, police gave my, recorded my magistrate.
I think Kukil Roy is one of our villager. Kukil Roy is not a relative. Huh.
Then what is the, see, what is interesting is that after 25 days, 164 was
Yes.
recorded
Hmm.
and 161 statement.
What's the immediately recorded?
164, he had,
In 161, what did he say?
Same. That fight in the
Porimol.
morning.
Or fight in the morning. Then he had killed.
Huh.
He also mentioned that he had killed.
No, yes. Others are regarding that, the running away by this Porimol. Informal statement, he said.
When it was recorded, 161.
Recorded on.
one 164 was recorded on 28/9.
Yeah, there is 25 days.
Yes,
So after a long time.
yes.
So let us see, because 161 will be instantaneous, there
Yes.
must be more natural.
Mm.
Let us see 161 statement, though we are not relying on it, but then
Okay.
we'll have some idea.
Contradiction.
Appears to be consistent what the deposition in the court. Especially the Porimol Roy, the key eyewitness.
Hmm.
We had come to cut here. In the village, it doesn't matter whether rich or poor, no?
It
See.
happens amongst the cousins.
Huh?
It happens amongst the cousins. They come and cut each other's
Come
hair.
and just because you are rich doesn't mean anything. Village, there is not so much of that class.
Huh.
Class differentiation is not there.
And he is the nephew, so he comes.
Some
and-
people are rich, some people are poor, but they still together, live together like this. So,
As far as the evidence is concerned, of course, the eyewitnesses account is not demolished. It is there. And other witnesses also corroborated. Some had seen him running away, chasing, and those corroborations are also there.
Found as described by the.
body of PW1 also.
As far as 302 homicidal death committed by the accused is there. But
What?
whether it can at all be converted or something that, again, we
That,
need,
that okay, that 302 or that we'll see. But if you hack on the neck,
one single blow.
one single blow, therefore, maybe 302 also.
Mm,
Even if
Doesn't
there was
matter.
no previous enmity, the fact that you hit on the, so there was intention.
mm,
Intention can be derived from the act. The question is, what little bit concerns us is that
mm,
this fellow says, whole people and one of them killed. I don't know. There is a whole
mm,
very mysterious. Why he's insisting on that again and again?
mm.
Whole people came and one.
Under the two brothers, they are saying all court in religion, then why they will blame him?
And yes, also everyone says a very cordial relation, no
Cordial.
prior jhagda.
Hmm.
Discrepancies regarding from this PW two stated that she came to know from Porimol only. He told her that he was Sukumar killed her father. Then if we'll go by PW6, she said that he told her. If I go by PW3, then according to him, he told him actually these things.
Oh, this telling her, him, her, all these are all.
He ran, then he again came back according
These
to
are,
him.
they
he
are
said
not
that-
very, they are not very, see, substantial, inconsistencies. Somebody may, oh, I told her, then people memory also there, that, the trial the incident happened in 2011
Hmm.
and the recording of evidence was sometime in
13.
13, 2 years also sometime.
And along with that, in the judgment, I don't find a single line saying that the accused have understood.
It is
Although
what,
it is
this is
not-
what is bothering us.
This is what.
The evidence apparently is loaded against you. Question is, yet,
Hmm.
did the court take such sufficient safeguards,
Hmm.
precautions?
At least
Yes.
court have also not gone to the extent that who are those 4 persons? Could you name them? That question was also not
Correct.
asked.
Because it
I
was a
guess
duty
I-
of the court to ask
Yes.
such questions
At
also.
least if he had
Huh?
said the 4 persons.
Evidence Act, what is that? The court, duty of the court to ask to a certain question, the court can put question to any
this
witness
is
at any,
put,
to ascertain the real truth. Indian Evidence Act,
forgot,
আছে না?
any questions can be put.
At
Yes,
any
and
stage,
that too, he is a special one.
yes, any
This
question
is-
could have been put.
Will be around examination chief and cross perhaps.
And if necessary, the court could have asked for another expert, find out what he's
yes.
saying. Section of what? Here, Evidence Act. One 65? The judge may, in order to discover or obtain proper proof of relevant facts, ask any question he pleases in any form, at any time, of any
yes.
witness or of the parties
Hmm.
about any fact relevant or irrelevant, and may order the production of any document or thing, and neither the parties nor the agent shall be entitled to take any objection to such question or order, or without the leave of God to cross-examine a witness upon, see, 165 is a very powerful tool in the hands of the court. This
We
is to be
find
used at this time.
We
Yes.
find court putting questions.
Yes,
in
we
some
find,
cases.
then you can ask, okay, this 4 witness, what does it mean? Just clarify, what does it mean?
I'll just read out Lordship 2-3 paragraphs from a Chhattisgarh judgment
Yes,
on this deaf and dumb being the accused.
yes,
I'll just read out slowly. In
Yes,
the
yes.
case of Emperor, this is a very old case of Allahabad High Court, has held that in dealing with deaf and dumb accused charged with serious offences, it is essential for a court to record a finding whether the accused can be made to understand the proceedings. Of course, before passing an order of Section 318, before making a reference to the High Court, a trial court has to record a finding whether he has been able to understand. But again, it is said, it is further held that where a deaf and dumb person is committed to stand his trial in the court of session or is convicted, a reference has to be made under Section 341, now it is 18, of the CRPC as a matter of measure of extra precaution, so that the High Court may satisfy itself that under the circumstances, it was a fair trial or inquiry, and in case of an order of commitment, the court will give directions. So normally it should be referred to the High Court to see. And it further goes on to say that A deaf and dumb will also face the same conviction as a normal person.
Correct.
There is no,
Yes, that is
there is no second.
Yes, so long
opinion.
as he is able to understand,
Ah,
he has
so-
given a fair trial.
Yes,
That will not give him any benefit.
Yes.
this is what is said by the High Court. He had the court making reference, of course, should record that he has sufficient intelligence to understand the criminal character of the act committed by him. He may not be an answer, he may not be a man of unsound mind. And find out better decisions
Better
where,
decision.
because not
I
a
have-
single line.
Yes, I have requisitioned the service of my two law clerks also.
Ah,
They will
yes.
assist you.
Mhm.
You can get in touch with madam also, huh? Don't
Oh,
hesitate.
yes,
With
yes.
Visita also, get in touch, because idea is we want to find a law,
Mm.
how to deal with this kind of situation. Where the deaf and dumb has been charged and also
Mm.
convicted.
Mm.
Because if he has been denied, if you feel on the basis of records, evidence that he has been denied proper or fair trial, that can be a ground for setting aside
Mm.
the conviction. And he has been in jail for 8 years, perhaps.
Mm. Since
Yeah.
the day of his arrest.
Since the day of arrest means when you were arrested,
On
was
the
it
very same day,
11.
11?
11.
Oh, he has not been on bail also.
No, what I find is he's brought from custody.
There's been about 10 years, 11 years now, he has been in
more
jail.
than 11 years.
11 years.
In that
the-
Chhattisgarh judgment, his sentence is also lessened.
Oh,
So now he has been there for 11 years.
though it is RI,
Mm.
Yes.
so rigorous in for life,
Mm.
which means life,
Mm.
till
Right.
you die.
Unless remitted.
So he
I'll
has
see,
been in.
I'll see.
So please check it then, we'll take it up then.
Mm.
Visitor, we'll take it up some other day
Gotcha.
and just come up with that some material. Because we want to lay down this, some guidelines also, is important, because it
Yes.
can happen.
I've never done this deaf and dumb being
Yes,
accused
that-
against,
in
but
fact,
I've-
that is what struck to me.
He must also communicate with the defense lawyer.
Yes, he must be able to communicate with defense lawyer,
Ah.
unless defense lawyer himself is expert.
Oh, yes.
He can communicate easily with sign language
He has been given a lawyer by the court.
by the court. And the judge also must understand.
Mm.
Judge must also be able to appreciate what he is trying to say, what is question he wants to ask. Because he is in charge of the proceeding.
Yes.
And if he fails to give this certificate
Mm.
that it has been a fair trial, everything was okay. If he fails to do that, it may be a case
Mm.
of
If the science was required to explain to interpreter, why not the
Mm.
330?
yes, 313, yes.
Then
I know
they
at the time of
replace-
313,
Ah.
because 313 is normally one day affair.
Yes.
Then his service could have been requisition. Okay, you come, we are going to, court is going to ask some questions. You make him understand.
The order sheet, whether on that day somebody was called. 313 was exact. Was recorded on 9/1/2014.
14.
9/1/2014, the order can be seen once. I can see if you're not.
Present to the
Sukumar Roy.
14 or Dina Kumar, expert. Otherwise, to CW1 shows only charge. pending on- একেটাই আনিব পাৰো। 9/1/2014. And he was 24 years of age, I think, on the day of occurrence.
Must be around 35 or something, I don't know.
No, 24.
Now,
he
now,
was-
now, now.
Now. Yes.
Now, though, yes.
34, 34.
He's unmarried also,
Mm.
unmarried,
Yes.
unmarried. And what has happened to his property? Any idea? Huh?
Otherwise, one of them had said father had distributed the property properly.
No, after he is for RI in a
yes.
jail,
Yes, Lord.
he doesn't need a property now.
Is there?
So who is looking after his property? The person who is using it, you find out.
Yes.
They will give a clue
Yes,
to
yes. The motive.
the motive.
Present.
He was present.
They joined the contract. Graduate officer wrote details
Oh,
and
I see.
Acha.
Accused person is produced from custody
Mhm.
Sri Jayanto Kolita, graduate teacher, government deaf dumb is
Oh.
present as an expert to aid the court in putting questions under 313 CRPC.
Acha.
Accused. Accordingly, the relevant questions have been so asked on the, I am satisfied that the accused person had understood the question substance and have answered a question after understanding them, which are recorded in separation kept on record.
So same
But
person.
what about other witnesses when, but that has to be done on every occasion when exam,
Yes.
because you, that, in
On
exam.
each and every day.
Every
actually.
day, whenever the evidence is recorded,
Ah,
produced jail, hazard, remanded, fixed above. Asinaki. Accused for, accused is produced, expert, there is also absent.
With intimidation showing cause of absence.
So it appears that the expert was there,
mm.
but then 18, was he present on every, expert is absent. Press
Okay.
summon. Usable, accused is produced from jail, is remanded till. Accused is produced from jail, expert is absent.
Acha.
This is before.
Otherwise, it Korea ছিল.
No, but then, no, let us see, during the, see, recording of evidence,
This is started from 10
10,
10.
Ayo Anjan is present to depose in present, in place of, he is examined, cross-examined, discharged, but then there is nothing to show that
The present started from 10-9.
10-9,
When it was
accused is
fixed
produced,
from-
he is deaf and dumb and is for examined 313, so, okay, it will be required.
So
So court requisition for 313,
3 and 3.
but not for the other,
Others.
Oh,
that may also vitiate.
we'll see some
It
decision.
is present, PO is on training, some smart IO. Let us see. Accused produced 2 witnesses including Emma the present, Emma is examined, cross, declined, discharged. Other witness examined, cross, but there is no,
Expert not there.
expert is not there.
So at that time,
One-
we charged them 313.
He has
Yes. So from the record, it appears that when the witnesses were examined,
Cross-examining. No.
the PWs were examined, accused is produced from custody, there is no counsel, AKRO engaged defense tribunal, an expert, namely Jayanto Kolita requisition, hard operation, produce the material record. I am satisfied prima facie case is made out. Accordingly, charge under this. So charge framing, he was there.
And 313.
Yeah, 313 was there.
313 also he was there.
But accused is produced, seen, filed on and so on. So the unstated praise allowed for evidence. Accused is remanded. Accused person present. 4 PW are present there, examined, cross-examined, discharged, but no presence. So
I'll find out some
please,
case
huh?
law.
So-
He must know that what has been deposed against him.
he must know what is being
Oh,
deposed.
yes.
But he doesn't know.
He has
He can't
not
hear.
heard. He did not hear.
Deaf and dumb. He can't hear. He
was
can just see
simply-
somebody standing and muttering something, or he can see the lips moving.
In on 313, only a portion of the video.
The
is
portion.
there.
Then
Only
it has to
portion.
be translated to him with sign language. This is so and so, he so and so, all those.
Whether this will result in.
And the
fair
question
trial.
also will be asked, how does this lawyer know that these are the question he has to be asked? How does he interact with this
Yes,
deaf and dumb?
he has to be sure.
The
to result in-
consultation,
Yes.
because the question if you have asked, he has to
Yes.
consult, he has to
Yes.
aid.
What answer he has to repeat.
And he has to, because he has to brief him. This is what you want to ask.
All this has been said also.
All this said, and this is, and his advice, what is advice also necessary. Don't ask this question, what should we,
How to answer.
how to answer,
Everything has. sir.
not tutoring, but the guide,
Guide, yeah.
legal aid, legal
Mm.
assistance. This has been asked, therefore this must be asked. Do you know anything about this? What question to be asked? Defense can ask any question, no, relevant or irrelevant also, to shake the evidence of the witness. How does he do, unless he is in touch with the, so these are areas, I think, important. Visitor, please also find out, don't bother about only Indian law. Go to other jurisprudence. For example, in UK, say, or in America, or some other countries, what kind of procedure is adopted?
Yes.
And if you find it in India, then fine, no problem.
Yes.
Then you don't have to refer to other jurisprudence.
Mm.
But if there is no such provision, except for 318 and such,
It only,
Ah.
I think.
if that is so, if there is no detailed procedure, for example, there is the High Court rules are there to record evidence.
That
Ah,
we can also
164.
receive.
These are format. Though which is not given as CRPC, it is given the rules. You have to, these are the questions to be asked. Detailed format is there. If there is no such format in the High Court rules, see, sessions rules, rules, civil rule, that both civil rule and the criminal rule also, because in civil rule also there may be
Yes.
litigation
Provisions.
between
Defendant.
defendant also involving, then what kind of procedure is adopted? See from all these aspects, so that idea is to ensure that the person is properly represented, whether accused or plaintiff also. Even in civil suit, he may be a plaintiff. He will like to sue. How does he sue? How does he ask?
Principles will.
So same thing, but more it becomes important, significant in criminal cases, especially an accused, when his life and liberty is at stake.
And heinous crime.
Heinous crime. 302. That is why,
Procedure, there might be somewhere.
therefore, even in, there are so many judgments by Supreme Court, then even if he pleads guilty,
And even then we have. to
no,
go.
don't go. With serious crime, unless the court is satisfied, he has fully understood the implication.
Still,
Don't go by this pleading guilty. You ask the prosecution to lead evidence.
go
That's what the
direct.
law is,
Hmm.
isn't it? Why? Important is that the idea is that the accused must understand the implication, understand what is being said against him, so that he can take a proper decision on the basis of his understanding. If he lacks the understanding, how can he make a decision for himself?
And reply properly.
Reply
in
properly also.
313.
So kindly see, Indian jurisprudence, other jurisprudence also. So, and if these are not, safeguards are not provided, then a trial may be vitiated. We don't know. Yes. Okay.
Gotcha.
Any other matter? Today is over, huh? Okay. Yes,
Can you-
mister.
It was taken up
Yes.
after 2 weeks or 1
After
week?
when? Just tell us when. Give a date, then if it is better, if it is fixed.
Thursday, Lord.
It's
Thursday.
next Thursday.
It will be in the list only.
It will list, but then Mr. He will keep a note. Informal, list, prepare informal list which is prepared.
First of December.
Okay, next Wednesday, next Thursday. And if you keep it, in case there is a time, we'll take it up.
Not yet.
Because there is only area of because if you are able to show that non-provision of this kind of facility or this kind of precautions will vitiate, we don't have to go too much into detail of the
Lordship has to remand it in that.
remand,
case.
yes. But otherwise, we'll go into the merit if otherwise.
After so many years, remanding will also be. not
Yes, that
very-
is what we have to decide also. After 11 years,
11 years.
with the nature of the case, then we may have to go a little bit on the merit of the case.
I'll see whatever I.
Now we will see that.
get it.
Yes, what do you want, Mr.?
Item 59 is there. Lordship will take.
But then Jahan is not ready. He's not ready. We can read her mind.
Yes. 59 next week?
Item
Because she's not ready. If she's not ready, then we are also then difficult.
It will be in the list next
It
week.
will be the list.
Monday, Tuesday. Wednesday.
It will be in the list. You try your luck, no problem. Like especially Friday, you see your luck sometimes. Fridays or Wednesday, sometimes it may, Monday, Sunday, you don't know. Sometimes
Matters finishes early.
early, then you may take it up.
Today I tried it.
But then